A common question I receive is, can't I just add my children's names to my property and avoid probate? This is a great example of doing something that's somewhat easy, but you create new, multiple problems at the same time. Joint tenancy with right of survivorship is the co-ownership of property between two or more people. Upon the death of a joint tenant, their ownership interest is extinguished, and the remaining joint tenant then owns 100% of the property. Does this method avoid probate? Sure, but you create two new problems and one big tax mistake at the same time. First, you no longer own 100% of the asset. Therefore, you are no longer in control. You can't sell it, change your mind, or obtain financing secured to the property without the consent of the other joint tenants. Second, if something happens to one of the other joint tenants, such as a divorce, bankruptcy, or judgment being entered against them, then your property is now affected because they own the property along with you. Obviously, this creates a substantial risk to you. Third, your beneficiaries lose the tax benefit of acquiring the property through a trust or probate upon your death on a stepped-up tax basis. Here's the deal. When you give a gift during your lifetime, the donee acquires the donor's tax basis in the property. That means what you paid for it. For example, if you bought a house a long time ago for $80,000 and now the house is worth $300,000 and you decide to put your children's name on title as joint tenants with right of survivorship, their tax basis in the property would be what you paid for it, i.e. the $80,000 instead of the $300,000 that it's worth when you did it. Therefore, if you die and they decide to sell the house, they would pay capital gains on the $220,000 difference. At a tax rate of 15%, that means they would pay the IRS $33,000 in capital gains taxes. However, if you were to set up a trust and transfer the house into the trust, you accomplish the same goal of avoiding probate without all the risk. You still control the asset and you can do whatever you want with it. The actions of your beneficiaries don't have any effect on the property because they don't own it with you. And third, when you leave the property to the beneficiaries through a trust at the time of death, your beneficiaries acquire title to all of the assets on a stepped-up tax basis valued date of death. So in the example, if you bought the house for $80,000 and it's worth $300,000 at the time you die, then your beneficiaries acquire it at the $300,000 value and it becomes their tax basis. Therefore, in turn, when they turn around and sell the house for $300,000, which would be the same value they received it for, then the beneficiaries would pay zero in capital gains tax. Therefore, you've conveyed an extra $33,000 in wealth to your beneficiaries simply by setting up a trust. Plus, you've eliminated all the risk associated with owning the property as joint tenants with right of survivorship. The purpose of estate planning is to have peace of mind knowing that you have a plan in place to handle whatever comes up. I offer a free consultation over the phone or by video conference. If you have any questions, please send me an email. I look forward to hearing from you. Thank you for your time.